Sorry.
Okay.
Karen, do you want to start us off?
Sure. Hi, good evening, everyone. My name is Karen Neuwirth. I'm special counsel to the Oregon Justice Resource Center's Fair Law Project. And I'm really delighted to be here tonight to help lead this webinar together with our partners at Don't Shoot Portland. We want to thank the organization, its executive director, Teresa Rayford, board president Ty Carpenter, who are here with us, together with my colleagues from the Oregon Justice Resource Center, Zach Winston, our policy director, Olivia Bouchot, staff attorney at the Fair Law Project, Adam Gregg, legal assistant, and Beatrix Lee, our communications and policy associate. We're also joined by Maggie Powers, an attorney at the Community Law Division of Metropolitan Public Defenders. We know that SB 819 is both an exciting opportunity and a potentially confusing one. So we have decided to offer this community webinar to first, during part one, offer an overview of the statute and some background to how we got here, and a general overview of who it might help and what the process will look like. Part two of the webinar, which has not yet been calendared, but we will update all attendees here, will address specifics of at least one county policy and possibly more, as well as any questions that arise today that we're not able to get to. So the way that the today's webinar is going to work is we're going to talk about what SB 819 is, who is eligible, what relief is available under 819, what does it mean for a conviction or sentence to no longer serve the interests of justice, which is the operative language in the statute, the process for seeking relief, considerations people might have in deciding whether or not to go forward and seek relief, and then some background about how we got here and where we might go in the future. Finally, we're going to reserve some time for a question and answer at the end. Folks can feel free to post your questions in the Q&A as opposed to the chat. If you look at your Zoom bar at the top, you'll see Q&A. You can just type in questions and our moderator will go through those, pose those to our panelists at the end. At no time are we in a position to give legal advice throughout this webinar. We will not be able to answer questions relating to specific cases. So given the number of people who are here and the many questions that folks may have, we'd ask you kindly to try to frame your questions relating to general matters. And again, part two will offer more detailed information related to specific policies and also answer any questions that we're not able to get to today. So thank you again on behalf of OJRC and Don't Shoot Portland for coming. We really appreciate your attendance here and we will do our best to answer all of your questions and provide you with the best information that we can. I'll also note before I begin that a copy of the PowerPoint slides that we're using are posted in the chat, as well as a very detailed outline. And those two documents will be reposted throughout the webinar for folks who may join later if you don't have an opportunity to open and save them. I'll also point you to a number of available resources, which you can then find in the outline in these PowerPoints or on OJRC's SB 819 website. I'll read you that address now, although it is here and in the materials. The website at OJRC is www.ojrc.info/819. And that page will be updated as new information becomes available, but there you'll be able to find a copy of the statute, a link to a copy of the statute itself, the statute in Spanish, our frequently asked questions about the statute, that document also in Spanish, and then links to DA policies by counties and descriptions of those policies. So with that, we'll jump in. So SB 819 is a second look statute that allows some people who have been convicted of some crimes to seek review of their sentence or conviction. The goal of the statute is to give relief to people whose sentences or convictions no longer advance the interests of justice. So that's the language of the statute. Sentences and convictions that no longer advance the interests of justice. And we'll talk about what that means shortly. It is very critical to understand that relief under SB 819 is only available if the office of the district attorney that sentenced you agrees to file a joint petition seeking relief with the sentencing court. So the district attorney that sentenced the person who is now seeking relief has to agree that they are entitled to relief, and then a court will hear that claim and make a decision on the relief to be granted. Finally, it's worth noting that there is no right to counsel for SB 819 petitions. So who is eligible for SB 819 relief? This SB 819, the statute, provides for certain eligibility requirements, and those have to be met in order to get relief. But the individual district attorneys may also have additional requirements or considerations depending on the county where the conviction occurred. Likewise, even if all of these eligibility requirements are met, both those that are set forth in the statute and any additional ones that the district attorney, the sentencing district attorney has included, a person may still not get relief. It is entirely up to the sentencing district attorney's discretion whether or not to move forward with that joint petition and ask a court for relief. So what are the requirements for eligibility? Under the statute, relief is available only to persons who were convicted of felonies. So if the conviction is for a misdemeanor or a violation, you cannot get relief under SB 819. The felony cannot have been aggravated murder, and the felony cannot be expungable under ORS 137.225. And we'll talk about what crimes are expungable under ORS 137.225 in a minute. And I'll repeat myself that individual DA policies may add additional requirements. So it is not enough to simply say, okay, I was convicted of a felony, that felony was not aggravated murder, and that felony is not expungable. You need to also look at the policy if it exists in the county where you were sentenced. This is a flow chart which you will find on that OJRC resource site that I mentioned, which just walks you through the process again. So you start with being convicted of a felony. If the answer to that is no, you are not eligible. If the answer to that is yes, we ask, was that felony aggravated murder? If the answer to that is yes, you are not eligible. If you were not convicted of aggravated murder, then you need to figure out if your crime of conviction is expungable. If it's not, then you are eligible. So what crimes are expungible under ORS 137.225? Olivia is going to take over here and walk you through that.
Thanks, Karen.
Yep.
Hi, everyone. My name's Olivia, and I am with the Fair Law Project at the Oregon Justice Resource Center. So first, just a note about expungement. Expungement's a process to clear a person's record of a conviction, a dismissed charge, or a record of arrest. Now, unlike what you can do with an 819 petition, expungement doesn't affect your sentence. But as we know, having a conviction on your record will often impact other opportunities. So you might have problems with employment, housing, or even benefits might be restricted. So I'm just, right now, this is a lot of information, but I just want to point out that soon the Fair Law Project will have a new information page with a lot more details about expungement. So don't worry about us rushing through this for now. So while there are exceptions, broadly, the convictions eligible to expunge are Class B or C felonies, Class A, B, or C misdemeanors, or non-traffic violations. Now, I think the eligibility requirements for expungements are laid out really nicely on the next slide, so maybe we can pop over to that slide and look at that for more of a visually pleasing look. But so first, you're going to make sure you have an eligible offense like we talked about for eligible to expunge. And then you want to make sure you've completed any that fully complied with and performed the sentence of the court for the offense. So this means you've completed any sentence of incarceration, you've completed a term of probation if you were given one. If your probation was revoked, you want to make sure at least 3 years have passed since that date of being revoked. And finally, you've paid all related fines, fees, and restitution. So just a note about fines and fees. There's an option for if you're just financially unable to pay these, the court can waive fines and fees. So this might be something you want to reach out to the court about if you're in a situation where you're not able to pay your fines and fees and you might be otherwise eligible to expunge this record. You might want to consider reaching out to the court about that and just giving your financial circumstances and the way the conviction's affecting your life. Restitution's its own beast, unfortunately, because there's a victim involved, even if the victim is Safeway. So that is different kind of situation. But fines and fees might be worth reaching out to the court about getting those waived. So finally, you want to make sure to be eligible to expunge that you don't have any pending criminal cases in any court and that the relevant waiting period has passed. So this will be based on your most recent conviction. So, and it'll be your most recent conviction in any court, state or federal in the United States, or from the date of your release if you were incarcerated for that conviction. The waiting period depends on the type of conviction you're trying to set aside, and again, is measured from that date of the most recent conviction. So if you're looking to expunge a Class B felony, you're going to have to wait 7 years from your most recent conviction or date of release from incarceration if you had a sentence of incarceration. For a Class C felony, you're going to have to wait 5 years from that most recent conviction. Class A misdemeanor, you're going to have to wait 3 years. And if you're trying to expunge a Class B or C misdemeanor or a violation, it's going to be 1 year waiting period from that most recent conviction. I keep saying that just because it's confusing that you're measuring the date not from how long it's been since the conviction you're trying to expunge, but from the most recent one. So in our next slide, we're going to just kind of go over convictions ineligible for expungement. So these are the ones that you might want to be looking to file an 819 petition for. So any Class A felony conviction is not eligible to expunge. person felonies, and there's a big list that's kind of described by the Oregon Criminal Justice Commission. These are, you're kind of looking for crimes that are characterized as violent or with the potential to cause injury to another person. This list isn't always intuitive, so, but I just want to point out again that when we have that expungement eligibility information slide on our website, that information page, we will include this list of person felonies and other ineligible. Traffic convictions are also ineligible to expunge, and you can look anything that's charged under the 800s for the Oregon Revised Statute, that's going to be a traffic conviction. Almost all sex crimes are ineligible to expunge. There's a very specific exceptions to this that are outlined in the statute, but for our purposes, just know almost all of them. And finally, I wanted to plug the Portland Community College Clear Clinic. They offer free expungement help in Portland and some other legal services, and they're awesome. So that's it for expungement eligibility, and I'll be around for questions at the end as well. Thank you.
So returning to what and who is eligible to seek SB 819 relief. Again, if your conviction is ineligible for expungement and meets the other requirements of 819, meaning it's a felony and it's not aggravated murder, then you are likely eligible. But this question about expungement is an important and somewhat confusing one. And so again, the PCC Clear Clinic can help, and additional resources that OJRC will be putting up will also help. Okay, so what relief is available under SB 819? The relief available is actually quite broad. So again, if you meet the criteria for SB 819, you have established that your conviction or your sentence no longer advance the interests of justice, you can think about a wide range of relief. That could include dismissing all of the charges against you in their entirety, vacating your conviction, releasing you from prison, supervision, and any other reporting requirements or collateral consequences of your conviction. The charges against you could also be dismissed, and you could be recharged with a new alternative offense, with a new resentencing following a plea to the new alternative offense. This could result in either a lesser sentence than was originally imposed, or your release from prison if you have already served the new sentence in full. And likewise, it could include relieving you from any collateral consequences, reporting requirements, supervision, and the like. A third option is vacating your prior convictions that may have enhanced your sentence and resentencing you without the prior convictions. This could also result in either a lesser sentence or your release from prison if you have already served that new sentence in full, and relieving you from any other consequences of the conviction. Finally, the existing conviction can be maintained, but you could be resentenced to a shorter sentence if it's allowable under the law. This could result in either a lesser sentence or release from prison if that sentence has already been served in full. So what does it mean? How do we think about whether a conviction or sentence no longer serves or advances the interests of justice? The statute is new. There is not a lot that has been written about this by courts, but some general ideas about when a sentence or conviction no longer serve the interest of justice are the following. That you can establish that the sentence that has already been served is sufficient to deter you and or others from committing future crimes. That you have demonstrated that you have been rehabilitated during your incarceration such that additional incarceration or other penalties would not serve any further rehabilitation goals. That you're unable or unlikely to commit future crimes. That continued incarceration is harmful to others and or the community. When viewed today, as opposed to when you were sentenced, the sentence previously imposed was excessive to the crime of conviction or was otherwise unfair, that the sentence previously imposed would not or could not be imposed today, meaning that the law has changed in some way such that you would not get that sentence that you received earlier today. SB 819 sets forth some specific statutory considerations that should be considered in determining whether or not a person is entitled to SB 819 relief. Those considerations are a person's disciplinary history and record of rehabilitation during incarceration. This, of course, would be for the purpose of showing rehabilitation, for the purpose of showing an unlikelihood of committing future crimes or the like. And so anything that a person can gather in terms of records or statements from folks who have had the opportunity to observe you during your incarceration, or if out on supervision, that would show that you are unlikely to commit crimes, that you are different today than the person who committed the crime, that the causes of the contributing causes to the crime are no longer present and the like. Which brings us to the next, the likelihood that the person will commit future crimes or engage in violence. This is often much the same: participation in therapeutic programs, community service, steady work record, changed circumstances, anything that would show that the likelihood for further committing future crimes is diminished would be important to show. How the release would affect the safety of the victim, if any, associated with the conviction. So for crimes that involved a victim, the statute urges that, you know, the release would not negatively affect that person. Now, that's a complicated one, and we would strongly recommend that no one contact a victim or complaining witness in their case. If you have an attorney, which of course you're not entitled to free counsel, but if you have an attorney, this might be something to discuss with them. But individuals acting alone and no one on their behalf should contact the victim in a case or a complaining witness. The amount of the original sentence served. So the more of the original sentence that's been served likely will be viewed as a reason in favor of granting relief. And then any further changed circumstances since the original sentencing that show that the person's continued incarceration no longer advances the interest of justice. Now, the statute makes clear that while those listed considerations are relevant, they are not the only considerations. So a person should think carefully about any way in which they can show that their sentence or conviction doesn't advance the interests of justice. So, for example, if you can demonstrate that you are factually innocent of the crime that you were convicted of, or that you had some diminished responsibility for that crime that was either not presented or not sufficiently considered by the court at your original sentencing. Where new information exists that somehow shows that the conviction and or sentence was fundamentally unfair. So that new information could again go to an error in a factual understanding in taking a plea agreement, or that the circumstances of the crime were not as egregious as was previously understood, or that there was mitigating circumstances that no one was aware of that were not presented. That the collateral consequences a person is suffering are fundamentally unfair. So most often this has to do with a criminal conviction that prevents a person from obtaining steady, decent work, or living in certain types of housing, or having access to their children. So where the collateral consequences are hindering a person's ability to live a full civic life, that would be a relevant consideration. That one's continued incarceration or their record of conviction is harmful to others. So if a person is a provider or an important person to a minor child or an elderly relative, and there is no one else who can provide the emotional, psychological, relationship support to those people, where the continued incarceration is harmful to them, or the fact that you can't work, or you can't live nearby, or you can't travel freely because of your conviction. Those would all be important considerations. Where communal or social norms have changed, and those changes undermine the fairness of the previously imposed sentence. So this, of course, depends on when the original sentence was imposed, but over the last 5, 10, 20 years, communal norms have changed dramatically about things like incarcerating people for drug crimes, or the understanding that addiction is a health problem and not something to be criminalized, or that certain lengthy sentences are no longer appropriate. Courts in Oregon and elsewhere have recognized that people's brains continue to develop until they're 24 and 25. And so courts have recognized that juveniles and people in their early 20s may not have the full capacity for decision-making that an adult would have in deciding to commit crime. So if those sorts of communal norms and social norms were not recognized at the time of your sentencing, those things might be relevant to relief under SB 819. That the previously imposed sentence was, and let me, just add in terms of communal and social norms, another relevant consideration is whether or not a person was themselves a victim of abuse or violence that then contributed to their conduct. That is something that has been recognized as something that mitigates criminal responsibility and has not always been considered by courts in the past. That the previously imposed sentence was either excessive or otherwise unfair. So for this factor, you can think about whether, other people who were sentenced for similar crimes or are today being sentenced for similar crimes are receiving much lower sentences, or if there is some evidence that your sentence was affected or infected by racial bias or some other protected category, your gender, your sexuality, your national origin. If you can establish that you were sentenced more harshly than similarly situated individuals who don't share those characteristics, that would be a way to establish that your sentence was unfair. Any other individualized consideration that speaks to the sentence or conviction no longer serving the interests of justice. So we can imagine changed circumstances where at the time you were sentenced, there were other people in your family who could support elderly or ill people, or you have a child now and you didn't then. Any kind of changed circumstance, in addition to those that we spoke of a moment ago, rehabilitation and deterrence, should be raised. And then finally, that the previously imposed sentence would not or could not be imposed today. And we'll talk right now about what some of those areas are. So one, I'm going to skip the first bullet and come back to it, but these three bullets deal with Oregon Supreme Court decisions that change the law in ways that may be significant. So the Boyd narcotics delivery cases, if people know that they were sentenced under a theory under the Boyd case in which based essentially on the quantity and nothing more, you were charged with delivery, that may be ripe for SB 819 relief. I'm slightly hesitant as we raise that now because the Oregon Supreme Court has recently granted review of the Hubble decision that came down in 2021. So let's put an asterisk next to that, but that may be a case. Areola Boteo traffic stops, where prior to 2019, traffic stops were permitted, and and then we're allowed to engage in searches. The law has changed on that, and so may be an area where SB 819 can grant relief. And then merger issues, and the case at issue there is state versus pay, and essentially, without getting into the complicated facts of that case, has to do with basically getting charged multiple times for offenses that share factual patterns, persons involved, date, time, and the like. And the Oregon Supreme Court said, no, you can't get essentially multiple convictions for the same set of acts. So what is the process for seeking SB 819 relief? First, a person must inform the sentencing district attorney that they believe they are entitled to relief and ask the sentencing district attorney to file a joint petition with them. The way that this request to the sentencing district attorney is done varies by county. Some counties have fillable applications that are available online. Others are very open-ended and say, we would like to hear from you, send us a letter, tell us what conviction you're looking for relief from, what is the relief that you're seeking, and why do you feel entitled to it, while other counties ask for extensive documentation and have many other requirements. So again, I'll point you to the Oregon Justice Resource Center SB 819 page, which will link out. You'll see if you scroll down that page, it links out to our chart of county by county policies, and you can read our summary, but also please click on the link for your county and read the policy and what is required for your application. Assuming that the sentencing district attorney agrees that you're entitled to relief and agrees to file a joint petition, you and/or your lawyer will, together with the district attorney, reach an agreement about the appropriate relief, right? Whether it's you're going to have the same conviction, but we're going to resentence you to less time. We're going to vacate your prior conviction and have you take a plea to some new crime with a new lesser sentence, et cetera. So the parties will agree to what is going to be the relief. And then a joint petition will be submitted to the sentencing court by your sentencing district attorney and you and/or your lawyer, and the sentencing court will then hold a hearing. The statute does require notification of victims in crimes in which another person was involved, and different district attorneys handle that differently. As you'll see when you look at the different county by county policies, some district attorneys have taken the position that they will only agree to seek relief if the victim affirmatively agrees. Other district attorneys will simply notify victims if they exist, and those victims will be permitted to speak at the SB 819 hearing. So that's the third step, is that the sentencing court will have a hearing to determine whether or not the person is entitled to relief under SB 819, and if so, whether the relief shall be what is sought in the joint petition or something else. Some final notes on the joint application requirement. So SB 819 maintains the district attorney as the gatekeeper here, as is probably obvious to you by now. So relief is only available if the district attorney says, yes, I agree that you're entitled to relief and I am willing to file a joint application on your behalf. This is, for those of us who have worked for a long time in the criminal legal system, this is a concerning aspect of the statute, because we have seen the ways in which prosecutorial discretion has not benefited those charged with crimes, people who've been convicted of crimes, BIPOC people, the poor, and so on. And prosecutorial discretion is at the heart of this statute. Similarly, the fact that prosecutorial discretion is at the heart of this statute recreates the same relationships that have existed historically between prosecutors and those communities whose members have been most over-policed, most over-criminalized, most over-prosecuted, and most over-sentenced, who are therefore those who are most in need of SB 819 relief. And finally, what we see already is that DA policies vary wildly, and some counties' policies make it nearly impossible for an otherwise eligible person, meaning a person who's otherwise eligible under the statute, to get relief. Or those policies make it so burdensome in terms of filling out paperwork, collecting documents, and submitting those that it may not be worthwhile. So that begs the question, if you're eligible, how do you think about whether or not you seek relief? And the best answer that we have is that you need to consider the particular risks and costs to applying and weigh those, of course, against the potential benefit of getting some form of relief under SB 819. So some of the risks and costs that to applying that are worth mentioning are that statements in an SB 819 application could negatively affect you. So first, they can be used against you in other proceedings such as clemency. Whatever you write in your SB 819 application is going to essentially make up a form of a permanent record and could be used against you if you seek relief through clemency or in other proceedings. In theory, it could result in additional separate criminal charges if, for example, the application contains statements that the district attorney deemed to be false or inaccurate, or statements that the district attorney deems constitutes admissions to other crimes under certain circumstances. So that's first. Second, the process of applying may take up significant valuable resources, your time, your energy, your money, especially if some of the district attorney policies require the collection and submission of many documents. Third, your application will become a public document subject to release pursuant to public records requests. So this is not a private document between you and the district attorney. Any member of the public could seek the release of the document, and subject to public records laws, those documents could then become public. And so you need to think about whether or not what is in your application would be something that might be embarrassing or otherwise not in your best interest to have shared publicly. And finally, and this is a concern to me personally as a lawyer, and I think to other lawyers, is that a person who doesn't have a lawyer helping them through this process could unwittingly waive the attorney-client privilege as to conversations and communications you had with your lawyer about your earlier criminal prosecution and conviction. So that is basically the overview of the statute. I'm going to turn this over now to Zach Winston, who's going to talk to you about how we got here and where we might be going in the future. And then we'll have 15 or so minutes for questions and answers.
Thanks, Karen. Hi, everyone. I'm Zach Winston. I'm the Director of Policy and Outreach with the Oregon Justice Resource Center. I'm just going to give a quick overview kind of on the policy aspect or legislative aspect. So Senate bill, so SB 819 was passed in the 2021 legislative session. I then listed out those in favor versus those not in favor. The Oregon, notably on this bill, the Oregon District Attorneys Association did not oppose SB 819. As we've discussed, SB 819 does require DA agreement. And so that likely factored into that decision. SB 819 is an improvement and it will benefit some Oregonians. But as we stated in front of the legislature in the 2021 session, additional legislation is needed to address cases where cooperation of a DA cannot be obtained. So some examples, cases based on innocence when new evidence is discovered or becomes available, people convicted of crimes that are later decriminalized, when new constitutional law is recognized or when the interests of justice require relief, similar to what Karen has discussed previously, but where the DA doesn't agree. So just moving forward, we're going to share updates and further efforts related to SB 819 and broadening it with community members on OJRC and OIP, which is the Oregon Innocence Project social media and website, as Karen has mentioned as well. And community members are encouraged to contact their representatives to support legislation addressing cases where cooperation of a DA cannot be obtained. And this is important, right? A lot of legislation, as constituents, community members have a lot of power to advocate for certain issues to be addressed by the by their representatives. And so broadening 819 to allow for in cases where the district attorney doesn't agree to seek relief is an issue that can absolutely be brought up when speaking with your representatives. So direct communication with your legislators is incredibly important and can help move the needle on this issue.
Thank you, Zach. So I'm starting to look at some of the Q&As that have been posted, and I've answered a couple, but we'll move on now, and Olivia is going to moderate those questions, and we've got our full panelists available to weigh in. So again, we appreciate you understanding that we can't provide legal advice, we can't answer case-specific questions, and just a reminder that this webinar is being recorded and will be made available on public websites, so you should bear that in mind.
Yeah, and it seems like we got a lot of questions in the chat, so I'm not sure if we'll have time for live questions, but just starting with, we're going to go one by one. I think the first one may have been about expungements. So the first question was, so person-to-person crimes are automatically ineligible. And I'm pretty sure that was related to expungements. So person felonies, as defined specifically by the Oregon Criminal Justice Commission, are ineligible to expunge. And those it's a long list of statutes that we will have available soon on our expungement information website. And so the next question was, could the criteria listed here, new information renders the conviction and or sentence fundamentally unfair, relate to new laws such as those prohibiting non-unanimous jury convictions in Oregon? Could someone bring forth an 819 claim under Ramos? And I think Karen kind of started to discuss that. If you want to expand on that, or
yes, I think that is also a changed law that that a person could use 819 to bring forth a claim.
Okay, great. Yeah. And then so the next question is, can my family participate in the 819 hearing in the same way that victims can? And I think the answer we got from Brittany is, looking at the statute, there's nothing in the statute that says either way. So you can seek permission from the judge to do that. Next question.
I think just that's a really important, great question. And, it's something that folks should think about, because all of, one of the really core ways of showing that a person's sentence doesn't advance the interests of justice is both showing their personal growth or development, but also the negative effects of their incarceration or of their criminal conviction on their loved ones and members of their communities. And I think so, to the extent that those folks can talk about those things, and also talk about how if a person is coming home, they will be provided with a stable environment, or that there is some sort of a reentry plan, to the extent that that includes housing or work or the like, those would all be very important parts of an SB 819 application.
And this is a question about social and communal norms. What about increased understanding of mental illness not being best served by incarceration? So what about that? And I think that's definitely something that should be addressed with these 819 petitions.
Yes, if it will be helpful, because I see a lot of these questions, we can talk more about changes in communal and social norms in part 2. I think whether we're talking about our understanding of addiction or mental illness and the effects of incarceration. There have also been a lot of studies about how there is sort of a tipping point in a sentence when a person is people become served poorly by longer sentences. So there are a lot of communal norms that we can address, and we can put that on the agenda for part 2, because I do see a lot of those questions.
And another question we have is this will just be a quick answer. Is this about getting lighter sentences or erasing convictions? And it's really about the agreement that you're asking for and agreeing to with the district attorney. So it could be shortening your sentence. It could be expunging. It could be something to do with your collateral consequences that are making your conviction fundamentally unfair. But yeah. And okay, so question 7. Do you feel that the stipulation of requiring DA agreement effectively makes this new law ineffective? Have there been any successful resentencing through SB 819? Maybe Karen and Maggie could, I know Maggie's submitted some, I don't know if they've heard back, but Karen, if you want to start that answer, do you want me to repeat any of it?
No, I see the question. So
Oh,
I do not think that the requirement makes the statute ineffective. I think that, first of all, yes, there have been some successful 819 resentences. I think that for all of the reasons that were discussed, this is one tool for decarcerating people, but it should not be the only tool.
I don't know, Maggie, if you've had any successful resentencing through 819 yet.
Yeah. Hi, I'm Maggie. I'm an attorney with the Community Law Division at Metropolitan Public Defenders. I'm currently working on collateral consequence SB 819s.
Oh, right, sorry.
And so we've been submitting SB 819 petitions since January, and we haven't heard back from DA's offices yet. So one thing to probably note is that if you do turn in an application, it might be a long wait time. So we've submitted petitions in January and still haven't heard back about them.
Thanks, Maggie. Okay, so let's go to question 12. We want to kind of drive this point home. Is the current DA in the county that you would work with, or the person acting as the DA at the time? Oh, sorry. Is it the current DA in the county or the person acting as the DA at the time of the conviction? Which one would you be working with?
It's the office of the district attorney where you were sentenced. That there may, that the elected district attorney might be a different person, doesn't matter, but you need to go where you were sentenced. Now, a problem may arise for folks if you took a global plea, for example, to crimes that occurred in more than one county. And so that's sort of a special circumstance where you might have to figure out, you probably would have to go to both counties and get agreement there.
Question, really important one. Would the resentencing possibly result in harsher sentencing? Now, by statute, this can't happen, so that is limited. But I think, as Karen mentioned before, you still want to be careful about what you're saying in the petition as far as opening yourself up to further risk of conviction. But they can't just up the sentence if you're asking for a lower sentence by these petitions. Next question, can SB 819 be applied for while awaiting a decision for commutation from the governor? And the answer is yes. How would I know whether to apply for 819 or a pardon from the governor? I think that's definitely a strategic question that I'm not comfortable answering. Karen, if you want.
Yeah, agreed. I think it really is so fact dependent.
Yeah.
That you would need best talk to a lawyer that knows your case and understands how what relief is available under each option.
And I am not seeing any other questions. Is anyone, am I missing any? Does anyone want to?
Well, yeah, Olivia, I can jump in real quick. Terry had asked a question about, whether I want to hear about DAs and having, if people have problems with district attorneys on 819 petitions. I think the answer is yes. I'm going to try to track trends throughout the state, which counties are and are not utilizing 819, and what cases are they generally declining to seek relief on. The caveat there is to not send me facts about your case outside of maybe the conviction and the some of the concerns you had with, or the issues that you had with the district attorney's office. But just want to be careful in terms of not communicating any sensitive facts to someone who's not representing you. So I put I don't know if everyone can see it. I put my email address in the answer to Terry on that. And so people should feel free to contact me and just give me an update if they did have issues with district attorneys. So.
Yeah, I would just add that we will, by the second part of this webinar, we'll have some other thoughts about providing information about your experiences, because that will be a very important part of whatever comes next, and whatever additional relief might be, should be sought and made available for folks in Oregon.
We have another question here. Is this resentencing judge during the SB 819 here? It says 816, but I think it means 819 hearing the same as the original sentencing judge. And this is actually something that's already coming up. This is county dependent. So in Deschutes County, actually, they are having these petitions go to the sentencing judge. But it just depends on what the county policy is for those. And a question for Karen is, can you recommend attorneys for these?
Not right now, but we hope in the future that we will have some pro bono attorneys who will be available to help. And please check our website in the coming months for updates on that. But unfortunately, right now, no, we can't. I think I saw some DA, Karen James asks, some DAs are in contested races. What is the question we should ask? Great question. I think you should ask them about their policies with respect to SB 819. Do they have a clear written policy? Are they going to be putting in additional obstacles or barriers beyond those requirements set forth in the statute? Are they allocating sufficient resources? As Maggie just mentioned, there are very long wait times as it is now, because these petitions obviously require significant resources to review. So what resources does an incoming or incumbent DA plan to allocate to this process? Those are some I think questions that would be worth asking. And also we will be soon posting on our resource website OJRC's best practices for DA policies. And so you can use that to examine policies to the extent they exist and make your decision about who to vote for.
I had a question that how to find county specific requirements, and for these you're going to want to look at the policy by county on the county's website. But we have on our 819 page that we can repost collected those policies in kind of one place and the links to those, so that's a handy place to look on our website. And we have another question, a really important one is will we be offering this information to adults incarcerated? Yes.
We are working on getting all of the information on the OJRC's resource page in English and in Spanish. We have in PDFs, and we are working to provide those to folks who are incarcerated. And then the last question I just want to highlight, because I think it's a great question and ties in nicely to what are the questions to ask DAs who are running for election or re-election. Are the DA offices required to report approved and denied request statistics? Zach is writing an answer. I think the answer is no, right, Zach?
That is, sorry, that is correct.
Yeah.
Unfortunately, the answer is no, which is why we're going to be taking on at least, some of that to be able to try and figure out what is actually going to be going on with 819 in the state.
Right. So we're planning to do data collection and publication so that we can understand better, whether or not Oregonians are being treated equitably on a county by county basis, and trying to make that transparent. So again, another great question to ask of a DA who's running an election is, what data are you willing to make public on 819 or anything else in terms of your charging decisions, sentences, and the like?
I'm not sure we got to this question. I know we're about out of time, but we have one that an adult incarcerated has asked for resentencing recently before 2022. Does that 2-year, sorry, I'm losing track of the question. Does that 2-year denial of the application apply? And Brittany pointed out the statute went into effect in January 2022, so it shouldn't apply, but checking with the particular DA is probably the answer for that. Did we miss any other questions?
There's a question about the link to the SB 819 county chart. I'm just not, because I have all my
Yeah, I'll grab that.
They're all spoken for right now. I can't get that, but it is also, it should be a live link or a link you can copy paste from the outline or the slides that are in the chat. So hopefully you can get that. Thank you. Well, thank you. Thank you to all of you for attending, to our panelists. Don't Shoot Portland, OJRC for hosting this, and make sure that we have your email address, and we will publish, we'll email you, we'll put up on social media and on the OJRC info page when part 2 will be held. This webinar has been recorded and will be posted, made publicly available as well. So please spread the word to all those who may benefit. Have a great night.
Thank you.